Good morning. Good morning. I think I'm live. Give me a minute to refresh my YouTube, get that muted so I'm not making noise. All right, my microphone is on. I think you can actually hear me. I have this habit of starting my live streams muted for a minute or two. I don't know why I do that, but I think I figured that out. Good morning, everyone. Let's see who's in chat. Hi, Rosie, Bipolar, Catnip. Oh, it's so good to see you guys. I hope you're doing well. Cheryl, Subel, MJ DeBella, thank you for the super chat. It's not every day you get a super chat from a Skyrim NPC. That's kind of exciting. Glad to see you here. Pam, Kathleen Hensel, how are you all doing? Oh, it's almost Halloween, so I had to have a pretty autumny background because I like Halloween. I can't wait for 2 days from now. Of course, my son is very excited about tomorrow, which is the release of the new Mandalorian episodes or something. That's our big holiday here in this house. Halloween is whatever. What time does the motion starts in 30 minutes? Okay, I'm coming to you live. We've got some news to catch up on about the case, talk about what we're going to see in this hearing today. So we'll go over all of that, and then we'll wait for the hearing to start. I do have the hearing live stream page open, so I'm keeping an eye on that, very close eye, because I don't want to miss a single minute of it. This will be done via Zoom, so it should be broadcast on Judge Boyce's site again, just like it has been in the past. Things are falling off my desk, Thank you, Tess. I did a very casual look today. This is the gingerbread palette from Too Faced, I believe, the new mini gingerbread palette, and a MAC lipstick. Very simple today. It was too early in the morning to go full glam and glitter, but there you go. So hi, what's going on? Yeah, Tracy Schiller asked, what about all the crap that means demanded as evidence? That's what I want to start with today. I was going to make a video about it last night, but I was like, it's already didn't it come out like 6, 7 o'clock at night? I was like, I'll just talk about it in the morning. So yeah, Mark Means sent a document. Let me put it on the screen. Might as well, so we have some time. So let's go over this real quick. If I figure out how to do the share screen, Chrome tab, let's go the PDF. Here we are. All right, this is the PDF. Let me get to the top of it, of Mark Means' letter to, is it showing up on your screen? There we go. This is the letter that Mark Means sent to Rob Wood just the other day. This is crazy. This is crazy. Basically, Mark Means, whoops, wrong one. He's sending Rob Wood this letter saying, hey, I asked you for all this discovery stuff and you didn't give me everything I wanted. So here's a very detailed list of all the stuff I want. And he wants, basically, it's kind of copy pasted down through the line. It says any and all audio or video recordings, communications, emails, text, social media posts, voicemails, videos, statements, pictures, police reports, and any and all agency reports, notes, charts, graphs, files, report compilations, or the like in regards to, and then insert the name. So Lori Vallow, he's asking for anything about Chad Daybell, Melanie Gibb, he spells it right there. David Warwick spells that wrong there. Zulema Pastenis spells that right. Charles Vallow, Adam Cox, that was surprising to me. Summer Shiflett, that was a little surprising. Melanie Boudreau-Pulowski, Ian Pulowski, Ethel K. Vallow Woodcock, which is K. Woodcock, Larry Woodcock, Heather Daybell, that was surprising. Any and all witness and potential witnesses, minor children, which would be in reference to JJ and Tylee. And then he also asked for all autopsy, toxicology, DNA, fingerprint, and other like records, reports, evidence, photographs, videos, on and on, about Charles Vallow and Tammy Daybell, spelled incorrectly because it's Mark Means. So he sends this letter to Rob Wood. All right, now I'm thinking, okay, all right. First of all, discovery is a thing. Right, Rob Wood will turn over the full body of discovery. He has a deadline to do that. He will do that in time. Mark Means knows this. So what is he saying here? I think that this is just a stunt because he released this. This wasn't just a private court filing. He actually released this letter. And Rob Wood responded with, let me change the screen so you can see what Rob Wood responded with, because I thought that was kind of interesting. Oh, here we go. Here's Rob Wood's response to this, and I'll read it quick. In our American justice system, prosecutors have a solemn obligation to ensure a fair trial for every defendant. This is a responsibility that I take just as seriously as I take my obligation to protect the safety of this community. An important part of ensuring a fair trial for the defendant is to provide appropriate information pertaining to the case to defense counsel. We have provided Mr. Means with a large amount of the information he requested, as well as items he didn't request. Given the complexity of this investigation, can't see past my camera, additional information is still in the hands of investigators and analysts and will be provided to the defendant, to the defense as soon as it becomes available. Another critical part of protecting the defendant's right to a fair trial is the avoidance of unnecessary pretrial publicity, such as the inappropriate release of this letter. For this reason, we have not and will not attempt to litigate this matter in the media. So, Rob Wood issuing a very stern response to Mark Means over here. Mark Means has made a week of it, hasn't he? He has his tweets earlier in the week that I had a video on, basically just pointing the finger at Melanie and David like, get them. Come on, what are you trying to do here? Certainly, for a lawyer, they don't need to make tweets and post letters like this in order to get what they need from the opposing side as far as discovery and information investigations. If Mark Means thinks that Melanie and David are somehow more involved, then he should have a private investigator doing his own investigation on that, not tweeting about it. So I think he's just trying to poison the jury pool, possibly even some witness tampering going on there. I think he's crazy. Do I think he's trying to be removed from the case? No, I do not. I don't think he's doing it intentionally to get removed from the case. I think Mark Means wants this case very, very badly. He thinks he's going to make a name for himself. I think Mark Means is a little deluded, to be honest. I think he's very much under Lori's spell. I think a lot of what he does is coming from Lori. Because imagine, Lori's sitting there in jail. She is probably furious at Melanie Gibb for ratting on her, hence the image of the rats. And she's like, I'm going to take them all down with me. Get them. Go get Melanie Gibb. She knows this. I really think Lori is pushing Mark Means to do this. Now, of course, Mark Means works for Lori. He has to do what she wants. But I think he's deluded enough and under her spell enough that he thinks, yeah, let's get him. I don't think he's thinking with his full faculties. Okay, I think he's under her spell. He's doing what she wants him to do. He's doing some things that are really dumb as far as I'm concerned. So there you go. CJ, I agree. I think Mark Means has made a name for himself as the lawyer you don't want defending you. Absolutely. He's making a name for himself, but not in a good way. I agree, Cherie, 100%. So that's what I think all of this is about. I think this is about pretrial publicity. I think he's trying to, like I said in my tweet to him, he's throwing Dookie at the wall and seeing if anything sticks. He's trying to come up with a whole bunch of other possible defendants. It's not even like a proper Denny motion. He's just throwing out names to the public to get other people mad at all these other people. It's crazy. Little Lady Di, thank you for the super chat. The sticker says you are amazing. I love it. Thank you so much. It's been a long time since I've talked to you guys, and I was actually a little nervous about going live this morning because it's just been too long. There's not been anything happening with the case. Lots of stuff going on in the background and in my life, and I've just not been in the right frame of mind for a live stream. So I'm very excited to be here today and to see all of you again. So I'm checking the court website, make sure we're not missing anything yet. Should be starting in 20 minutes. So I'm fading in and out. Is that the green screen camera thing? I've been messing with these cameras and this green screen for about half an hour this morning. I cannot get the edges to not be blurry and whatever, so we're just going to have to deal with that. But looks all right to me on my YouTube. So, yeah, Tracy, I'm trying not to be nervous. I am a little bit, but whatever. Okay, it looks good to everyone else. All right, good. So today's hearing. Today is going to be, I know I'm not looking at the camera. I'm looking off at chat. So I know that looks weird on replay if you don't even see the chat going, but I'm reading chat. today's hearing is going to be the motion for joinder, or motion to joinder, however you want to say that. Oh yeah, Halloween nails. Get cats on my nails. I have some very cool Halloween nails that I love Halloween nails. So the motion for joinder today is going to be basically Rob Wood is asking for Lori's trial and Chad's trial to be joined into one trial. Basically because he's saying they're going to be kind of identical trials, so why have two of them? That doesn't make sense. So I agree that they should be joined. John Pryor does not want them to be joined. Mark Means does. He waived his right to object, or Lori waived her right to object. So I don't expect to see Lori or Mark Means in the courtroom today. Mark might be there because certainly he has a vested interest in this, but we're going to be hearing from John Pryor, who's going to be arguing against the motion for joinder. Now, why would he argue against it? Well, of course, he is going to try to say, his defendant's crimes and Lori's crimes are separate. They're not the same thing, yada, yada. And he is alleging that having Lori as a co-defendant in a trial can hurt Chad's case. I can see that part of it. However, when it comes to cases like this, they're being charged with the same thing, although Chad has more charges against him. Remember, they both have 2 counts of conspiracy to conceal or destroy evidence, but Chad also has 2 counts of actually concealing and destroying evidence. All right, so Chad's case is more severe at this point than Lori's. So in that sense, Lori would be the one harmed by the joinder more than Chad would be. So Lori, Mark Means, should be the one objecting to the joinder. I don't understand what these guys are thinking. I really don't. I've watched a lot of trials in my life, and this one is like, what are you guys doing? I'm not a lawyer, but that's not even what I would have done. Jeez. Who motioned for the joinder? I believe it was Rob Wood, the presiding prosecutor. He is a special prosecutor in this case, so he was the one who wants them joined. Now, John Pryor filed a motion with the court, or a filing with the court, saying just a notice of authority, basically saying, I'm going to cite this specific case as precedent for how the court should proceed with this motion for joinder. And he cited Idaho State versus the state of Idaho versus Nava, Quentin Nava. He was arrested and tried for 2 counts of sexual assault, sexual whatever, against 2 minor females. Now, that case went through a whole bunch of stuff with the joinder because the defense in that case wanted a severance of the charges. Right? There were 2 charges against Quentin Nava, and his defense team wanted them separated, not one trial for both cases, because he said that one charge. Whoa! I just found. I'm sorry to interrupt my train of thought. I found a Kit Kat on my desk. Where the hell did that come from? I don't know what that's doing there. That just shocked me because it should not be on my desk. I don't know where it came from. Anyway, Quentin Nava's defense argued that their 2 charges should be severed. All right. And it went through all kinds of appeals. They tried to overturn the conviction, yada, yada. The state Supreme Court of Idaho said no. There's absolutely no reason that those charges should have been severed. The joinder stands, the conviction stands. Here you go. Now, I did put up all the documents on the Nava, the Supreme Court opinion, all this stuff. It's in the Discord if you want to read it. There's also links in my last video, so you can read all of the case history if you want on the Nava case to see how it applies. And that's the problem. I don't see how it applies to this case at all. It's not 2 defendants. All right. It was 1 defendant by himself. So right there, right off the bat, where's your argument against joinder for this case? It's not what's happening here. The only thing I can think of, and I did have some lengthy conversations about this over the weekend, is that what John Pryor wants to do is have a severance of the charges in Chad's case, either the 2 charges regarding JJ and the 2 charges regarding Tylee separated, or he wants the actual conspiracy charges and then the actual destruction or concealment of evidence charges, those sever. It seems like Mark Means is just gonna, or Pryor is just gonna say he wants some severance of the charges in some shape or form, but that still doesn't really fit this case. And the Nava citation really doesn't work here. So I'm very curious to see what he's going to argue, how he's going to argue this. Also, I don't think that he can come forward now in the motion for Joinder hearing and say he wants a severance of the charges. I think you would have to make a whole separate motion to sever the charges and not just bring it up here today. So I have no idea what John Pryor is thinking or doing with this. It makes zero sense to me. And I did prepare to make this whole long video about the Nava case and talk about, they wanted to sever these charges because this rule and that rule and da-da-da-da, and go through the whole thing to try and make it make sense. But in doing so, I could not fit that to Chad's case. And so I really don't know where Pryor's coming from on this. So it's going to be interesting. Also, in the links in my last video, and hopefully one of the mods can get it, go to the LoriVallowstory.com. Subscribe to that newsletter. It comes into your inbox. It's written by Lori Hellis. She's a criminal defense attorney, and she's my go-to person when I'm like, what on earth is going on here? Right, very good free newsletter, all about this case, all about the legalities of it. So there you go. Bipolar Princess has the link in there. You can subscribe. It's free. It's great. And I talk about her a lot. Certainly in the last video, I mentioned her and even put some links to the website so you can find it all. And I have an itch. The tag of my turtleneck is driving me bananas. So anyway, let's check on the judge's website and see. Nothing yet. We've got a few more minutes to go. 13 minutes. So, all right, let me check on chat because I was yapping and I was not reading chat. Probably will argue that the two incidents are not related. Yeah, he can try. He probably will argue that. But that would also be a motion to sever. I'm not sure if that's going to be germane to today's hearing. Today's hearing is about the motion for Joinder. So what he should be putting forth is his argument to the judge of why having Lori's case joined with Chad's could be harmful to his client. All right, so this should not be about anything about Chad's charges. It should basically say that having Lori there in the courtroom as a co-defendant is going to hurt Chad's chances of a fair trial. Does he have an argument for that? I don't see one. I certainly don't see how Idaho versus Nava has anything to do with that. So, I don't know. It's going to be a surprise hearing because I have no idea what's going to come out of his mouth, which is really weird. This is about John Pryor and Chad, but I have a question. Sure, Brennan Tube, what is your question? I am watching chat, so ask now before I get distracted and look away. Hi, Rosie Skies. How are you doing? Good morning. Donut time. Oh, yeah. He's looking forward to the appeal. Possibly. Certainly a lot of criminal defense attorneys will try to set up their appeal during the course of these events, but Rob Wood is maybe a little too smart for that. We'll see. Who do you think Lori would hire Mark Means, or why do you think Lori would hire Mark Means as a criminal defense attorney without an experience? Because I think she probably knew him, or he came referred from a friend from one of their little groupie people. You know what I mean? He's involved in that community, and that's how she found him, through word of mouth type of deal. So that's what I'm guessing about that. Will Lori be searching for hubby number 6? She may have found him. I think Lori and Mark Means have a very close relationship. I know that's complete rumor and speculation. Don't go running off into the world with that. Like anyone said this is happening. No, I would not be surprised if they're not very, very close. Eleni K, thank you so much for the super chat. Yay, good morning. I love that super sticker. Thank you so much. I really appreciate that. Oh, man. So he was an LDS. Yeah, probably. I would not be surprised. So, but from what we see of Mark Means with his tweets about the Woodcocks, his tweets about Melanie and David, those seem to be coming right from Lori's mouth. Don't you think? Because she has got to be so angry. We knew that she was mad at Kay before any of this happened. She hated Kay Woodcock. Absolutely hated her. Certainly she had a million reasons to hate her. Mm-hmm. And she certainly is so angry with Melanie and David for turning on her. How dare they have the audacity to turn on her? Even if they're not telling the complete truth, which I do not think they are, I think Mark Means actually has a point with his tweet. Melanie and David know more than they're letting on. I agree with that 100%. Do I think that the attorney should be tweeting that? Absolutely not. I think that's completely inappropriate. I did also put a link to the Idaho rules of professional conduct, so you can read through those. And there are certain places where it seems like, yeah, Mark Means you kind of messed up with that a little bit. So we'll see what happens as a result of that. Mark Means would have to be a blind, clueless idiot to fall for Lori Vallow. Yes, he would. I agree, Flame Lily. And I think he is. But that's just my own personal opinion. But let's hear about Melanie P. Melanie Pulowski. We don't know too much about her. Apparently, she did have a baby. It's a very healthy baby boy. I'm glad the baby's fine. They have their next hearing in November for the custody case between Melanie and Brandon. Melanie is listed in this discovery document that we saw, the discovery request that we saw from Mark Means. He does want all the information about Melanie and her husband, Ian. That's all we really know about what's going on with Melanie at this point. She's still listed as a person of interest in regards to the shooting attempt of Brandon and the disappearance and ultimate death of JJ and Tylee. So that's all we know. She's a person of interest. That's all they're saying. So maybe Means wants to be kicked from the case. I don't think he does, Kathy. I don't see anything. If he really wanted to get off the case, I would assume he could appeal to the judge. So I don't think that's what's happening. I think Mark Means is very naive. He's not used to a large criminal proceeding like this, or certainly the publicity that comes with it. And he is doing Lori's bidding. I think that's all he's doing. Let's see. Do you think Lee? I don't know. That's not something really worth speculating about. Mark Means has done multiple unprofessional things. He lied when, yes, he did. Yes, he did. That's right. Way back in the beginning, Mark Means said that he was representing both Chad and Lori. And he said that publicly. He even tweeted about it. And then when that was brought up by Rob Wood in one of the preliminary hearings, he said, no, I only represent Lori. Ha, ha, ha. And they actually had a closed door hearing about that to see if this was a conflict of interest. He should be removed from the case. Apparently, he convinced the judge that it was not a conflict and he was okay and he was allowed to stay on Lori's case. So we'll have to trust the judge on that. That was with Judge Edens, and we all love Judge Edens. So. Hi, Linda. Thank you. I have been well. I have been. It's just been a busy month in the private sector of my life. Do I think Lori and Chad will both be in trial? I'm not sure what you mean. I think they will both have trials. I think the Joinder will be approved by the judge. I really do. But we're going to have to wait and see. How long do you reckon today's hearing might go on for? Given that I think it's only Pryor that's going to be speaking, I don't think we're going to be hearing from Mark Means today because they waived their right to object to the Joinder. So I don't think Mark Means is going to have anything to say. We will hear from Rob Wood and we will hear from John Pryor. I'm going to guess at least a couple of hours. That's my guess. I don't know. Hopefully it'll be kind of quick because I hate listening to John Pryor and his microphone issues and his, quite honestly, Your Honor, foundation. Quite honestly, I need foundation. It would be funny to see Rob Wood do that to him, though, every time he opens his mouth. Objection, foundation. Yeah, we'll see. But Rob Wood does not play games. He's not playing around with these yahoos. So I would guess about 2 hours for the hearing. I hope Pryor learned to use the mic. Well, this is going to be a Zoom hearing. It's not going to be in person in the courtroom. So hopefully sound will be just fine. Will the judge determine today? He could. The judge could say he wants to take it under advisement and think about it. But that's one reason why we saw John Pryor file the notice of authority with the Nava case, to give the judge time ahead of time to review that case file so that he would, when they're taking it into consideration, the judge doesn't have to stop and go back and read that case. So hopefully he will give his ruling today. We're going to see. Lori will not be present, right? I would guess Mark Means will at least be watching, but he does not need to be there because they did waive their right to object to the joinder. So there's no need for Lori to be present today. We should see Chad, although Chad does not technically have to be there, I don't think, but I'm pretty sure he will be. Nope, Lori will not be there. You're right. Mark Means should be listening because he certainly has a vested interest in this, but we'll see. Oh, Flame Lily is joining Reese's Pieces. Oh, excellent. Welcome to the group. It's so good to have you now in Reese's Pieces. Oh, man. I want to know what they found on Tammy's. Danny, so do I. I cannot wait till the day when we get those autopsy results. All right, I'm not seeing the hearing yet, so just let me pull up another website. Give me 1 second. It's very hard to do that with nails on. Let's see. Where is the hearing? There should be live hearing. It is not live yet. Okay, we're not missing anything. It's okay. But I'm going to keep watching just to make sure. So I'm not seeing all of chat because I keep tabbing out to look at all the things. Karen Brown says, quite honestly, you got, Lori Hellis, hi, good morning. It's so good to see you here. Thank you for being here. That's Lori Hellis. That is the woman that I was talking to you about the Lori Vallow LoriVallowStory.com website where you can sign up for a free newsletter that gives you all the legal information you could want to know about this case. She really breaks it down in a way that you can understand and will help you know what all these hearings are about going forward. It's going to be a circus of a trial. So that's a resource that you definitely want to have in your back pocket. Bipolar Just Princess just put in the URL for it, the LoriVallowStory.com. For some reason, when we drop it, it doesn't drop as a link. I don't know. It doesn't do that for me either. So, but the link is in actually, it's in the description of this video. Yes, it is. Just look down the description. It's there. There is a direct link to it. So, hi, Justin Lum. What do you mean, hi, Justin Lum? Justin Lum is here? Oh, my goodness. Is that Justin Lum? Justin Lum is my hero. Oh, if that's really Justin Lum, oh, my God, I'm thrilled to bits to see you. Justin Lum, I have his links also in the description. Follow him on Twitter and Facebook. He's with Fox News 10. Whenever there's legal documents in this case, Justin always has them first. Always, except for the one that was missed the other week when I sent it to him. That was actually kind of great. So Justin is the go-to resource for all of the legal documents, which is, they're really hard to find. I still have no idea how to get into the actual court website to pull up these documents. Oh, here we go. We are starting. All right, let me, I'm going to share my screen, and I'm going to shut up as soon as I get this going. Here we go. Share screen, Chrome tab, the hearing. All right, give me a second. Oh, wait, I got to share it with audio. Hold on. We're not missing it yet. It's okay. Share audio because guys are going to want to hear it, not just watch it. All right, StreamYard. I'm going to make that full screen. All right, it has not started yet. Oh, here we go. I'm going to make full screen, and I'm going to shut up and put my headphones on, make sure we can hear it. Give me 1 second to get it all sorted for you. Full screen. All right, there's no technical noise yet, just some clicking. Can you all hear anything from that? There's just some like clicking. No one said anything yet. I'm going to keep an eye on this. We'll test the audio as soon as they start talking. But yeah, huge thanks to Justin Lum and to Lori Hellis for being here today. You guys are mainly the reason I'm able to do this. So I appreciate you and I thank you so much. And everybody, please check out all their links in the description and follow them everywhere. Yes, you can hear the clicking. Excellent. Okay. They should start talking any minute. KTV, it's 25 more minutes. Well, it's supposed to be starting now, so we're just going to leave it on this and see what happens.
Good morning, everyone. This is Judge Boyce. I'm appearing from Madison County. My chamber's here for this hearing this morning. This is case CR 22-20-755, State versus Chad Guy Daybell. This is the time we have scheduled for a hearing on a motion for joinder. The state filed its motion for joinder on September 1st, requesting that this case be joined with a different matter, which is case CR 22-20-838, State versus Lori Vallow Daybell. The defendant in this case objected to the motion for joinder, filed that objection on September 9th. And Mr. Pryor also submitted a notice of authority on October 22nd. And I will just note as we get started here, Mr. Pryor is appearing with his client, Mr. Daybell, on behalf of the defense. Mr. Wood is here on behalf of the state, and we are conducting this hearing via Zoom pursuant to the Supreme Court's operating order. In the other separate case, the 838 case of Mrs. Daybell, she did file a notice of non-objection on September 14th, so it's not being objected to by the other defendant. So this is the time set for argument on the motion for joinder. Mr. Wood, is the state ready to proceed with argument at this time?
Yes, Your Honor.
All right, Mr. Wood, it's your motion. So if you want to go ahead and present argument, and then I'll hear any response from Mr. Pryor.
Thank you. Your Honor, Idaho Criminal Rules 8B and 13 establish the standard by which a court decides if two defendants should be charged and tried together or if joinder is appropriate. Rule 8B states that it's appropriate for two defendants to be charged together if they are alleged to have participated in the same act or transaction or in the same series of acts or transactions constituting an offense or offenses. It also establishes that each defendant does not need to have identical charges to do so. Rule 13 gives the court the authority to order that two or more complaints, indictments, or informations be tried together if the offenses and defendants, if there is more than one, could have been joined in a single complaint, indictment, or information. In the case before the court, Chad and Lori Daybell are both charged with 2 counts of conspiracy to conceal, alter, or destroy evidence. Chad Daybell is additionally charged with 2 counts of concealing, altering, or destroying evidence. The evidence in question for all counts is essentially the same. That evidence is the deceased bodies of Lori Daybell's children, Tylee Ryan and JJ Vallow. Both of the deceased children were found on Chad Daybell's property in Fremont County, Idaho. They were found after law enforcement discovered a text from Chad Daybell to his now deceased wife, Tammy, matching that text with geolocation data from the phone of Lori Daybell's now deceased brother, Alex Cox, gave law enforcement the location of the children's bodies. The Daybells are charged with conspiracy because the evidence which the state will present shows that there was a plan between the defendants in regards to the fate of Lori Daybell's children. The evidence in this case, the state believes, will demonstrate that the concealment of Tylee and JJ's bodies are the result of the same plan and the same series of acts or transactions which constitute the offense for which both defendants are charged. And that is the standard set forth in Rule 8B. I note that the standard is the allegation that they are alleged to have committed those acts. Beyond Idaho's criminal rules, the courts have made it clear that joint trials are appropriate. As mentioned in the state's brief in Zafiro versus the United States, the Supreme Court stated that joint trials play a vital role in the criminal justice system, that they promote efficiency, serve the interest of justice by avoiding the scandal and inequity of inconsistent verdicts. Currently, the defendant's cases are assigned to 2 different judges. This is highly inefficient as it requires duplicative work from 2 judges, their clerks, and their staff. It requires the state to perform duplicative work by creating a need to litigate similar issues twice in front of 2 different courts. This raises one of the most important issues in front of the court, as in most criminal cases, issues of evidence will be litigated prior to trial in these cases. It's inevitable. The trial court has varying degrees of discretion over the admissibility of evidence. As these cases are currently situated, it's entirely possible that an issue of evidence could be decided upon differently by two different courts. The state believes that could create automatic issues of appeal if that decision is beneficial to one defendant and yet harmful to another defendant. At this point in the proceeding, the requirement that the defendants receive a fair trial is better served by consistent pretrial rulings, which would help avoid the inconsistent verdicts discussed in Zafiro. In Bruton versus the United States, the Supreme Court stated that joint trials conserve state funds, diminish inconvenience to witnesses and public authorities, and avoid delays in trials. The witnesses in these cases are the same witnesses discussing the same evidence. And I'd ask the court to consider the fact that if these cases are tried separately, or even litigated prior to trial separately, that creates a great inconvenience and hardship on witnesses who live out of state. Witnesses in this case live in the various states of Idaho, Arizona, and Hawaii, and possibly others. Separate proceedings will create a great cost to the state in bringing those witnesses in for essentially duplicative testimony. The Ninth Circuit Court of Appeals in the United States versus Jenkins stated that joint trials are particularly appropriate where co-defendants are charged with conspiracy. The Idaho Court of Appeals in State versus Blake stated that an appropriate and fair trial can be accomplished in a joint trial, and the benefits of a joint trial in light of the allegations of conspiracy, as well as the need for the same witnesses and evidence, can outweigh other concerns. It's the state's contention that the rule for joinder should be construed broadly to allow liberal joinder to enhance the efficiency of the judicial system. One issue we did not discuss in our brief, but the state feels is very important, is the effect separate trials will have on pretrial publicity. There can be no question that separate cases requiring separate hearings will create more pretrial publicity. Consider the explosive nature of a story in which two different courts reach two different decisions on the same question of law or fact. The state has gone to every effort to protect both defendants' right to a fair trial, even asking the magistrate court in this case to refrain from broadcasting the preliminary hearing. Again, separate cases absolutely means more hearings, more media coverage, and more difficulty in finding a suitable jury. Mr. Daybell has provided the court with State v. Nava, as we discussed prior to this hearing. I would point out that Nava deals primarily with Rule 8A, which governs joinder of offenses, whereas the state is asking the court to make a decision under Rule 8B, which governs joinder of defendants. Nevertheless, the state acknowledges that joinder of offenses and joinder of defendants shares a similar analysis. It's important to note that the decision in Nava hinged on whether the defendant's multiple offenses shared a common scheme or plan. In the case before the court, we aren't litigating a common scheme or plan, we are litigating a conspiracy, which is the same scheme and the same plan shared by co-conspirators. Nava is instructive in its discussion of Idaho Criminal Rule 14. At the end of the day, the defendants must have a fair trial. If the defendants believe that joinder will prejudice them at trial, they may object and present evidence to the court on those grounds. At this point in the case, the court lacks enough information to make any such decision. Even if this court did find at some point that separate trials were necessary to protect the defendant's rights, at this stage in litigation, the requirements of justice and efficiency are better served by joinder of the defendant's cases under one court with one judge. A decision to join the cases now does not preclude the court from hearing argument under Rule 14 at a later time. The defendant always has the right, both defendants have the right to make that motion at any time prior to trial.
That would be a motion to sever that you're referring to?
Yes, thank you, Your Honor. A motion to sever under Rule 14. I would, as the court noted, the defendant, Lori Daybell, has filed a notice of non-objection to the state's motion for joinder. Finally, Your Honor, I would ask the court to consider the effect of keeping the cases separate, the effect that will have on the families of Tylee and JJ. They are victims in this case as well and have a right to be present at any physical proceedings it may have. Who knows how that will play out with COVID, but it's entirely possible that we will have many of these proceedings live. None of the close family members of Tylee and JJ live in Idaho, whereas due to the fact that Tylee and JJ moved to Idaho very soon before their deaths. And I'd ask the court to consider the hardship on Tylee and JJ's brother, the Woodcock family, the Vallow family, and the Cox family in keeping these proceedings separate. Consolidating these cases creates less hearings and less travel for those victims, and as such, less hardship. In conclusion, criminal rules 8B and 13 allow this court to make a decision to join these cases. The standard for joinder, again, is that the defendants engaged in the same acts or transactions or series of acts or transactions constituting an offense. And in this case, that's heightened by the fact that they are alleged to have engaged in a conspiracy. The state believes the standards clearly met in this case. Further, the defendant's right to a fair trial are protected by Rule 14 and the possibility of a motion for severance at a later date if necessary. And as such, the state respectfully asks this court to join Chad and Lori Daybell's cases into one case.
All right, thank you, Mr. Wood, for the argument. Mr. Pryor, argument in opposition.
Yes, Judge. Judge, I took the liberty of submitting State versus Nava to the court. I'm fully aware, and I appreciate Mr. Wood pointing out that Nava addresses 8A, but I think the analysis is the same. I think in good faith, I can't argue that the allegations, and I want to make it clear that they are allegations against Mr. Daybell and Ms. Vallow are similar in nature, and that under the prong of 8B, it applies, and the joinder does apply. The objection, Judge, that I filed talks about prejudice. Further, I appreciate that Mr. Wood recognizes that at any time in the future, I can file a motion for severance under 14 and say that trying these two folks in the same proceeding is highly prejudicial. Mr. Wood and I have discussed, and I'm not going to make a matter of this, but there's still some housekeeping that needs to be done in terms of discovery that Mr. Wood and I are going to privately engage in trying to resolve, and if necessary, we'll ask the court's assistance. But at this point, without all of the information in this case, I'm not in a position to argue severance on this date, and that's going to have to be reserved for a different date. But Mr. Wood's argument, Judge, to suggest a convenience to the court and expense to the county and the difficulty of witnesses is secondary. And primarily, Judge, the importance is Mr. Daybell going to get a fair opportunity to present his side of the story? And is it going to be able to be presented without any kind of prejudice or bias? Or are they going to infer anything from any other witness or any other defendant or anybody else that does not afford him an opportunity to fairly present his case? And although 8A doesn't specifically address bias, the Nava case talks briefly that there is still a prejudice or a bias, and the court can evaluate that. Now, I understand there's been an inordinate amount of publicity. Mr. Wood has pointed out examples of some of the publicity, and I've pointed out examples, and that's going to be reserved for a different date in November when we talk about venue. But the fact remains, Judge, that by linking the two of these folks together is still going to provide a modicum of prejudice. And although I have to concede that joinder, when you look straight at the rule 8A, that there is an allegation of similar facts in this case. The fact remains is what I would ask the court to do is reserve a ruling on joinder, allow the argument to be made in terms of severance once Mr. Wood and I have resolved our discovery issues, and decide at that point whether or not we're going to proceed in a common trial. I don't think it's an effective argument for Mr. Wood to suggest that he's going to have to make more effort and he's going to have to do duplicative work in two different cases. And I'm sorry that he's going to have to engage in that. But the fact remains that
I'm a little confused on, we don't get to severance without a joinder, because right now we do have two separate proceedings before two separate courts. So I guess I don't quite follow the argument of reserving ruling on joinder and then argue severance later.
well, and that's
Actually where in all we are, you could call it severed, because we have separate proceedings, separate judges right now.
I guess my feeling, Judge, is simply this, is that if the court joins the case, you're going to require the fact that I go through the analysis and we come back and there's going to be a continued hearing. Now the court understands it. Maybe I wasn't being particularly clear. I guess from my position is I would leave the status quo, because at this point, we are going to be going back and arguing these same facts again in a severance case once again, and I'm not beating on this, Mr. Wood, please don't take it this way, but once Mr. Wood resolves some of the outstanding issues that we have yet to resolve between the two of us. I guess from my perspective is that we proceed along as we are proceeding. And if at some point there needs to be a further ruling on the joinder, at that point we can go forward and do both of them at the same time. If the court doesn't want to do that, the court can make its ruling. And obviously, I think both of counsel and I have indicated the court there is the opportunity without further action for a motion for severance in the future, Judge. Thank you.
All right, thank you for the argument, Mr. Pryor. Mr. Wood, if you'd like to make any final rebuttal argument, you can do so.
I would just point out that the duplicative nature of work in this case, if the cases aren't joined, and the inconvenience that causes not only the state but witnesses and victims, is absolutely appropriate for the court to consider. It's one of the factors brought up in the case law presented to the court. Other than that, I have nothing else, Your Honor.
Okay, thanks, Mr. Wood. Well, counsel, I've considered the motion. I'm prepared to make a ruling at this time. As I mentioned when we started the hearing, this motion's been pending for quite some time. It was filed on September 1st, so almost 2 months ago. The concerns the state brings up as reasons to join the cases at this time I've considered, and I have to look at the two-prong analysis that's set forth in the case law and supported by the rules under Rule 8 and Rule 13 of the Idaho criminal rules. And the two factors I look at is, number one, under Rule 8B, is there a common scheme or plan to support the joinder that is alleged to have occurred in these two cases? And then part two is, would a joint trial of the two defendants be prejudicial, looking at joinder under 13 of trying the cases together. So as I mentioned at the outset, in the other case, which is Mrs. Daybell's case, CR 222838, there was filed a notice of non-objection, and that is part of the consideration. But looking at the first prong, I think that's easily satisfied under the allegations of the two cases. In each case, there's been a complaint filed in one. In Mr. Daybell's case here today, that's an amended criminal complaint filed on June 30th. But both cases have charges of conspiracy to commit destruction, alteration, or concealment of evidence. And in each case, or each complaint, I should say, that's pending in both cases, there's a list of overt acts that are alleged to have occurred in support of the conspiracy charges, and two separate sets of overt acts. When I review those complaints, the overt acts are identical as to both cases, and the charges themselves all relate to the common evidence the state would bring forward at trial and the common witnesses based on those conspiracy charges. So it's pretty clear that the first prong of whether or not there's a common scheme or plan is supported under Rule 8B for joinder of the offenses in this case. And then looking at whether or not the joint trial of the two defendants would be prejudicial, there was an allegation in the response that was filed that this would create additional publicity, which would prejudice the right of Mr. Daybell to a fair trial if these cases were joined. I've considered that. I've also considered the arguments of the state that having two separate courses run in two different cases with two different judges could result in separate evidentiary rulings. There could be some inconsistencies. There would be duplicative hearings. And I think quite concerning given our circumstances right now under our COVID restrictions and the difficulties we have even getting a jury trial at this point, the prospect of having two separate trials where two separate juries would have to be impaneled to try each case is concerning as well. And so when I look at all the factors and the supporting case law, I don't find that the prejudice at this point has been demonstrated that would be sufficient to prevent me from joining these cases. And so based on the analysis and consideration of the citations also provided by Mr. Wood, and also in due consideration of the new case that was cited by Mr. Pryor, the Nava case, I read through that as well. I do find the facts of that somewhat inapplicable to the issue I've got at hand. That's where a single defendant had a trial involving separate multiple victims, which were put together in a single trial. Here we've got two defendants with a single common scheme or plan that is alleged. And so upon consideration of all that, council, I am going to grant the motion to join at this time. As the parties indicated, that doesn't forego the possibility of a future motion for severance if prejudice is demonstrated by the defense in support of that motion. So clearly, Mr. Pryor, you have that opportunity going forward if you believe the prejudice would exist after we get further down the road with these cases being joined. But I am going to order the joinder of the cases. I'll grant the motion. Then Mr. Wood, if you'd submit appropriate order, I'd appreciate that.
Yes, Your Honor, we'll prepare that order.
All right. Mr. Wood, do you have any questions regarding my ruling today?
No, Your Honor.
All right, Mr. Pryor, any questions from the defense regarding the court's ruling?
No, Judge, thank you for your consideration this morning.
All right, thank you very much, counsel. I appreciate your preparedness this morning and your briefing and arguments. And if there's nothing further, then we'll be in recess.
Thank you,
Thank
Judge.
you.
There we go. My mic was unmuted. Okay, there we go. That's a thing. The judge has granted the motion for joinder. Not surprised. Some interesting things came up. First of all, like we talked about before this hearing started, the motion for severance. I said it sounds like Pryor wants to argue motion for severance of the charges in some way, shape, or form, but that's not what this hearing is about. That would have to be a separate hearing. Turns out that guess was correct. Even Rob Wood pointed that out. This is not a motion for severance hearing. Nava doesn't apply. The judge said Nava didn't apply. I'm like, okay, I'm not completely crazy. That was good to hear. It was really short, Bethany. I agree. I did not expect it to be that quick. I thought Pryor would do a lot more proselytizing of his views, but he didn't. So there you go. The trials will be joined as of this point in time. It's possible now that Pryor will file a motion for severance, either of the two cases or the charges or something. Who knows what he's going to do? He's going to try and string it out, I'm sure. So there you go. But I'm very, very glad that the judge kind of saw through the baloney. It was like, what are you even talking about with Nava? That doesn't even apply. Sit down. So there you go. Now, one of the biggest reasons that I'm glad that this happened, first, I'm going to admit I'm a terrible person, but this is going to make the trial that much more circus-like, because when we get to watch the trial with Chad and Lori there together and the two lawyers kind of working at cross purposes to each other, that's going to be one heck of a trial to see. I'm excited for that. But the main point of having them joined is what Rob Wood has been saying all along. We don't need to have two trials. We don't need to go through this twice. We don't need to call all the witnesses twice to say the same thing. We don't need to put the victims through hearing this testimony twice for no good reason. All right. So absolutely, for the protection and comfort of the families and the victims, this is the way to go. It's also going to save the state a whole lot of money because putting on a trial is not cheap. So there you go. So I'm very glad that the judge decided to do this. I think it was the right decision. Now, I can see where Pryor is not going to enjoy this. However, Pryor seems to really not understand that his client, the case against Chad, could be far more prejudicial to Lori's case than Lori's could be to Chad. So whatever. Just I'm convinced now that Pryor and Means are a little cuckoo and they don't really get it. I'm not a criminal defense attorney. I'm not an attorney of any kind, but I think I get what's happening here more than they do. And that should be concerning because, geez, guys, come on. All right. Would both Means and Pryor be present? Yes, they will both be present during the trial. They will not be joining. It's not like Chad and Lori are joined as one unit. They're just both trials will be happening concurrently since there are the same charges. But all their charges stand. Lori's got the 2 conspiracy, Chad is the 2 conspiracy, and the 2 concealment and destruction of evidence. So Chad has 4 charges, Lori has 2. Lori also has 3 other charges still pending in Madison County. So who knows what's going to happen with those now. So there's a lot going on. But if you want some case history. Oh, wait, whoa. Lori Hellis just said, the argument for severance is the argument that there will be undue prejudice. Expect that motion from both lawyers. Okay, great. All right, so we will stay on top of that. Yeah, one thing that Lori Hellis has said in her emails very clearly is how Chad's case can prejudice Lori's case far more than Lori can prejudice Chad. So I do expect to see that coming up. But then again, given what Mark Means has been doing lately, who knows what he's going to do? He thinks the Joinder is a great thing. Okay. So yeah, this is going to be a circus of a trial. But the trial is scheduled for January. I don't think that's going to happen. I think we're going to see some more motions come up. We're going to have more hearings. We're going to have some delays. I don't expect this to get going much before like April of next year. So we're just going to have to be patient. But of course, we will stay on it every step of the way. So now the cases are going to be joined. Yeah, if you wanted to look up some trial history of things that might explain what's going to happen with this, assuming it goes forward like this, check out the McNabb Bell trial. All right, we had 2 defendants charged with the same crimes, 2 separate attorneys, separate cases, but they were joined into one trial. We also have, you can look at the Rosenbaum case, Joseph and Jennifer Rosenbaum. 2 separate defendants, 2 different charges, but they shared one attorney. All right, and that got very complicated and very messy. That even went to the state Supreme Court for the state trying to force them to have separate attorneys. So that's some interesting case background, some legal background. If you want to see how these joined trials and cases work. Yeah, check that out. Also, what was I going to say? There's something else about joined cases. I don't even remember now. But yeah, look up McNabb Bell, look up the Rosenbaum trial. You see how they can work in different situations. We'll get an idea. The Groves trial, that was also a joint trial. And then we have cases where there were similar charges, but they were separate. What was that? The big case out of Florida? The doctor that was murdered by her husband, well, murdered by guys hired by her husband. That was a big case. There were different defendants, different trials, and how they all played in amongst each other. So the Severs case, yes, the case of Dr. Teresa Severs. So check out those 3 cases if you want to see how joined and severed or unjoined or not joined trials work together. That's a very interesting case to check out. So Mr. Wood looked greedy for a second or 2 and the judge rendered his decision. Oh, Rob Wood, I do not envy him this case that he has before him. Now, one thing that I did want to touch on before we leave today, in the documentation, well, the letter that Mark Means sent to Rob Wood about discovery, right? Saying, well, I want everything about all of these people, Summer Shiflett, Adam Cox, Charles Vallow, Tammy Daybell. He's asking for all the autopsy reports, all of anything that the state has on all of those cases. Bethany Valdez, welcome to the team. It's so glad to have you as a new member. Thank you for joining. I appreciate the support. All right, so, sorry, reading chat. Mark Means wants all of this information. A lot of people have asked me over the last 12 hours, why does Mark Means want all the autopsy reports for Tammy and Charles, and what is he going to do with that information? Does this mean that he thinks Rob is going to bring murder charges? It's possible. Now, certainly, Mark Means understands that his client is in a giant cauldron of hot trouble. Okay, because not only do we have JJ and Tylee, The only thing we're looking at so far are the conspiracy to conceal or destroy evidence regarding JJ and Tylee's remains. That's all we have so far. There's going to be more coming at some point. JJ and Tylee are not the only people who died in Lori's orbit. We have Joseph Ryan, we have Charles, we have Tammy. We have Alex, so why is Mark Means asking for all of that? Now, Tammy's autopsy report is not particularly directly germane to these charges, but they could be. They certainly could be. So I think what he's just trying to do is go on a giant fishing expedition to see what Rob Wood might be planning for the future. Remember, Rob Wood is a special prosecutor in this case. He can bring charges in some of these other crimes, certainly anything within his jurisdiction. So there could be more. There could be something about Tammy. There could be something about the shooting attempt at Brandon. There could be something about Alex. Charles is in another state. Joseph is elsewhere. But Rob Wood can oversee a lot of this. And I think that Mark Means is trying to get ahead of that. But I think that his letter was more just to put it out to the public, just to put all of these other people under a spotlight, like Summer and Adam and, the Cox family and things like that. I think he's just being a meanie face. Not to make a stupid pun, Mark Means, but, I don't know. I don't see it happening that way. But let's see, check up on chat. The attempt on Brandon. Yep. Now, remember, we're also following the custody battle between Melanie Pulowski and her ex-husband, Brandon Boudreaux. All right. And there's a lot that's going to come out in those hearings. They have already, the evidentiary reports that we have seen, they show that they're going to be talking about the shooting attempt on Brandon. And Brandon is all but saying Melanie did it or Melanie was behind it. Doesn't say that exactly, but she is listed as a person of interest in that investigation. And that's going to come out as part of the custody hearing. So I really think that custody hearing could be quite material to this case going forward. So we're going to watch that pretty closely because murder charges will come after their conviction. It's possible. Remember, this is a giant investigation that spans far more than just conspiracy to conceal evidence. Right? We're talking about the deaths of 2 minor children, the deaths of 2 spouses that are directly related to Chad and Lori. We're talking about Charles and Tammy. We also have Alex, and then we have Joseph looking back in, more historically. But it wasn't that long ago. Joseph died in 2018? I think. I don't even remember now. This case has so many moving parts, it's hard to keep them all straight. But so we've got 6 people dead and 2 people at the center of all of it. So that is a big, giant investigation for Rob Wood to deal with. And he cannot bring charges until he is sure he has enough evidence to secure a conviction. Otherwise, he could lose the chance to actually get justice for those crimes. So we have to be patient, as hard as that is. Yeah, Joseph did die in 2018. Okay, thank you, Manuel. That's what I thought. The Boyd trial in Knoxville was joined for 5 defendants. That's right. Another good case if you want to look at how joined cases work in trial. The Boyd trial in Knoxville. That was a crazy case and a very crazy trial. So check that one out. Will the 2 trial dates be canceled and a new joint date set? Karen, I'm pretty sure that the dates that we have are not going to be accurate now because we're going to have more motions. Pryor's probably going to file a motion for severance and it's all going to get delayed. So don't take a week off for January to watch the trial yet because we don't know if that's actually going to happen. So, Kristen and Company, yes, the cases will be joined. The judge ruled today that that Rob Wood's motion for joinder should stand. He denied John Pryor's objections to it, and there you go. The cases will be joined. Is that going to last? Who knows? We'll see what Pryor puts forward, but. Mark Dedding says, I hear the Arizona authorities will wait until the day after. Well, we don't know. We don't know what they're going to do. A lot of people are saying a lot of rumors about charges from Arizona. All we know for a fact is that there are investigators, or at least a lead detective, working on the case from Arizona regarding Charles's death, who says that they are still investigating it. They are looking at it. And maybe, possibly, there will be conspiracy to commit murder charges or something for Lori someday. Okay, that's all we know. All of that is still totally up in the air. It's still, we know nothing. We know nothing. I would like to see those charges happen. Absolutely. And I hope they do. But we're just going to have to wait on that. Remember, unless you hear it from law enforcement or, attorneys in the case or something like that, consider it rumor until we see an actual document. So that's why we watch Justin Lum. Follow him on Facebook and Twitter, Fox News 10. That's where you're going to get all the documents. Okay. And as soon as he gets them up, I take them, read them, come up with my opinion on them, talk to people, and get a video about it, usually within a day. So I try to go solely based on actual court filings, documents, and evidence, not speculation and rumor, although there's a lot of it in this case, but try not to do that too much here. Any autopsy ordered for the dead brother? Susan, are you talking about Alex? There was an autopsy done on Alex. The toxicology report was released, and it shows no strange thing. Basically, they said that he died of natural causes. So who knows what that's all about? Who knows? Let's see. Chandler Police Department dropped the ball. They did drop the ball badly. They absolutely did. It's just Robbie. In a horrible, horrible way. Absolutely horrible way. I think if Chandler Police had responded appropriately to the initial calls from Charles, we wouldn't be sitting here talking about this case today. Nope. So, I'm not sure. I believe Alex was definitely cremated, but they do have deep tissue samples that they have kept. I'm not sure about Joseph's. There is some information regarding Joseph's cause of death and stuff that was released recently. All those documents are up in Discord, but nothing showing a nefarious cause of death. Okay, they all seem to show natural causes. Yes, you can kill people with insulin. That is a possibility, and that's something that's very hard to trace forensically, because insulin exists in your body, and it's one of those difficult things to trace. So, who knows, but hopefully we'll get more information with, all the digital information. Certainly in Charles Vallow's case, they're talking about the lead detective himself said that they were tracing the digital footprint of everyone involved in that case to get information. So, maybe we'll find out that way. There could be some emails or some texts or some phone calls, or at least locations of people during some of these events that will make what happened more clear. So we're just going to have to wait and see. I am so thirsty. All right, Jen asked an interesting question. Does the joinder help or hurt the chances of Lori and Chad turning on each other? I don't think it really affects it either way. Because remember, Lori and Chad still have their separate defenses and their separate attorneys, and they're doing their own thing. Right? Just because, like if the jury wants to find Chad guilty of conspiracy, but not Lori, they can still do that. It's not like the jury has to say, if one is guilty, they're both guilty. Right? So it's not quite the way it may seem just because the trials are joined. So I don't think it changes whether if or will one of them turn on each other. I think it would make it more challenging to have a joint trial if one of them is sitting there pinning it on the other one. That could be a good argument for motion for severance. But one of them would actually have to come forward and, say something like that and make it an agreement with the prosecutor, I believe. So I don't really see that happening. I don't. Deborah Aries just got here in a summary. All right, what happened today? We had the motion for joinder hearing, which Rob Wood filed a motion for joinder with the court to join Lori's trial and Chad's trial so they could be heard together to spare the state, the victims, and the family members having to sit through two nearly identical trials for no real good reason. John Pryor argued against that. Mark Means, on Lori's behalf, did not object to it. And the judge decided today that the trials will be joined. So we'll hear them both together at the same time. So that's what we got for today. Yeah, Stephanie, I am very, I've always looked at Jason Mao and Julie Rowe and the Melanies. I'm curious that Jason and Julie did not show up in Mark Mean's little diatribe, 13-page letter, 8-page letter, something like that he sent to Rob Wood listing all of these. But yet he lists Adam Cox and Summer Shiflett. Curious, very curious. I wonder if Lori has not mentioned Jason Mao and Julie Rowe to Mark Means. Remember, Mark Means is only acting on the information that he gets from Lori and possibly private investigators if they have any. So we'll have to wait and see what he does there. All right, so that's all we've got for you today. I'm very glad that the motion for Joinder was granted. I think that's going to shake things up a bit. Still waiting for new charges. Yes, I know. I really, really hope we get them soon too. But I'd rather Rob Wood get these charges completely sealed and a secure conviction on them, get them in jail for a while, and then work on bringing more charges. So we're just going to have to wait and see. Now, before we go, a couple of links to let you all know if you want more resources for this case. First, we're going to talk about the LoriVallowStory.com. It's written by attorney Lori Hellis. Great legal background and information about this case and why things are happening the way they are. Subscribe to the free newsletter at the LoriVallowStory.com for that. Justin Lum and Nate Eaton, my two favorite guys covering this case. Justin Lum is from Fox 10 News. Nate Eaton is with East Idaho News. All of the links to all of their stuff should be in the descriptions below on almost all of my videos. Please follow them on Twitter, Facebook, their websites, etc. These are just some really good resources. If you're really interested in this case, these are the people to go to for the information hot off the presses, as it were. So I'll bring you any more hearings that come up. Right now, the next scheduled thing is November 24th. So not like for a whole nother month, but I expect to see more motions coming. There's going to be some sort of filing as a result of today's hearing. As soon as those are filed, I will bring them to you in videos. We'll talk about it. Going to get back to doing more live streams. It's been a hot minute. I miss you guys a lot. We'll be doing a Patreon live stream this weekend. So Patreon and channel members, stay tuned for that. You can follow me on Patreon. You can subscribe to the channel. Either way, you'll get to see the live stream this weekend. We're going to talk about all kinds of things, some case stuff and some not such case stuff, because there's a lot going on in my world that I want to talk about. So not all of it has to do with Chad and Lori. So I will see you on Patreon and the channel members over the weekend for that. And whenever there's news, I know it may get quiet around here sometimes, because if there's not news in the case, I don't want to just put up videos just talking about stuff we already know, just to have videos keep going for the case. I really want to wait for news. So there may be quiet moments, but I'm still here. I'm still working on stuff, still doing things behind the scene, and I'm not going to forget you guys. Okay, so I'll see you over the weekend on Patreon and for channel members. And any news that comes up, any filings, as soon as they happen, I will bring you videos on it and we'll talk about what it means. All right, so thank you for being here. I hope to talk to you all soon. Thank you to everyone for the super chats and new channel members. That makes me so happy. It makes me want to keep doing this. So thank you. I appreciate the support. Until then, go get yourself some Halloween nails, because these are super fun. And enjoy your Halloween. Have a safe and happy holiday. I'll talk to you all soon. Bye. As soon as I figure out how to turn this off, because I always forget that. There it is. Bye. Maybe. Maybe not. Let's try clicking it again.